Good evening. Good evening, criminologists and future criminologists. So for this session, we will be having the legal parameters of juvenile delinquency. The legal parameters of juvenile delinquency will be focusing more on the PD 603 and then Republic Act 9344 and of some of the laws that are important in dealing with juveniles and delinquencies. Now, the Philippine the Philippine Juvenile Justice and Welfare System and its legal parameters includes PD 603, that is the Child and Youth Welfare Code, the Republic Act 9344, which the Comprehensive Juvenile Justice and Welfare System. And then another one is Republic Act 7610, which is the Special Protection of Children Against Child Abuse, and then Republic Act 10630, amending some part of Republic Act 9344. Now, let us try first to discuss the important things or the important or salient features of Presidential Decree 603 or the Child and Youth Welfare Code, amended by Republic Act 6809, because Republic Act 6809 is the law that amended what you call as this age of majority, because the age of majority for PD 603 is 21. So the age of majority as prescribed by Republic Act 6809 is 10 years of age, or the age of majority already is at the age of 18. Now, these are some of the pertinent things that we should remember as prescribed by Presidential Decree 603. So, the decree is basically known as the Child and Youth Welfare Code of the Philippines. It is referring to a child or a minor or a youth as a one person. Okay, so it could be child or it could be a minor or it could be a youth. This law is trying to tell us that this is only one person. Now, anything or any person who is below 21 years, which is today 18 years of age, except those who are emancipated, will be included in this law. And we repeat, any person who is below 18 years of age, person below 18 years of age will be included on what are the things that we will be discussing here in this session. So all of the rights bestowed specifically by PD 603 is that it will be covering all persons who are considered as child or minor, or those below the age of 18 years old and below. Okay, except those who are emancipated, of course. So the word emancipation will be discussed sooner. Now, let us try first to define parental authority, because this parental authority is important in discussing PD 603. So first is the parental authority. So this parental authority is the totality of all the rights bestowed to the parents to the child over his person and personal property. Meaning to say that even the child is below 18 years of age, that the parents has still all the kinds of rights described by PD 603 to control or to be exercised by these parents. So these rights has no distinction whether or not the child is legitimate or illegitimate. Or when you speak of legitimacy, this talks about children who are born within the boundary of marriage. When you say illegitimate, these are the children who are born without the before marriage, should we say. Okay, so it does not mean say the legal child and illegal child. Okay, it will become a misnomer. So legitimate means these are the children who were born because the parents are married, and then illegitimate is considered the children who are considered as the biological son or daughter. However, this is not within the boundary of their marriage, or their parents has not yet been married yet. Now, this parental authority was provided to us by Chapter 1 of PD 603 on parental authority under Section A. So it provides therefore defines what is this parental authority. Next, what if the parents separated or separated legally or illegally? So if your parents has separated, the child's parental authority will be designated by the court. But remember is this tender years presumption that no child over 7 years of age, unless the parent is chosen to be unfit, will be separated to his or her mother. In case of separation of parents, no son, daughter will be separated from his mother. Okay, so that is 7 years old below. Okay, it must not be separated to the mother. If the child is above or beyond 7 years old, it will be his own choice, unless it is proven or unless the parent is chosen to be unfit or has chosen to be unfit. Now, the question here, for example, is what if the parent is a prostitute? Is he considered fit or unfit? Now, if the parent or the mother is a prostitute, it does not say, okay, and has or it has been the mother has been unfaithful to the husband, okay, does not render her as an unfit or unfit mother. So that prostitution or the mother being unfaithful to his husband will not render him an unfaithful. What is important here is, so long as the mother can provide the basic needs of the child and it does not affect the child totality, okay, it will not be separated from him or from her. Okay, so in case of if the parents are still both alive and there is disagreement, okay, the law says it is the father's decision who shall still prevail. Okay, unless there is a judicial order that it is the otherwise, or there is an order coming from the family court that in case of disagreement, the father's decision will not be followed. Now, in case of absence or in case of the absence or death of either parent, what happens now? Okay, in the absence or in the death of another parent or either parent, if the mother has died, it will be the father who still continues the parental authority, or vice versa. If the father died, then still it is the mother who will be taking charge of the authority or exercising the authority. Now, what if this mother who has been whose wife died still remarried? Okay, in case of remarriage, it does not affect the parental authority over the child. Okay, so still parental authority over the child continues even you decided to remarry. Okay, that you still have the authority over this child, except if the court appoints another person that he will be the guardian or custodian of your child or of these children. Remember that there will be no child over or under 7 years of age shall be separated from his mother unless the courts find any compelling reason to do this kind of separation to the mother. Okay, so when will we say that a mother is unfit? Okay, the mother will be considered unfit if the mother is insane. Okay, which of course, it will be certified by authorities, and that there is the mother contains communicable diseases, or another is that he is really maltreating this child. Are cases wherein the mother's right over the child below 7 years old will be extinguished, will be having a compelling reason to separate this mother from his child who is below 7 years of age. Now, what is the order in case of death or the absence on the suitability of parents? That means the substitute parental authority shall be a surviving grandparent. That means there is no parent, both parent in case of the death. In case of the death of both parents or absence of unsuitability of parents, or the court finds no more suitable guardian, what happens here is that the the parental authority will be substituted or given to the surviving grandparent. Now, as per laws here in the Philippines, we said that what if the child's grandparents to the mother side and grandparents to the father side is still alive? Okay, well, the law says it must be first on the paternal grandparents. So when you speak of paternal grandparents, these are the grandfather on the father's side. Second option is that the maternal side. So the side of the mothers, if they are still alive. Now, what if the paternal grandparent, maternal grandparent is absent or has been or is dead? Now, the oldest brother or sister will be taking charge of the parental authority. Now, in choosing the what you call as this, the older brother or sister, it should be over 21 years old. Unless, of course, if it is unfit again, who declares that it is unfit? It will be the court, okay, or any other authorities, or unqualified. Okay? If the child does not have brother or sister beyond 21 years old, or his brother is considered unfit, or it is disqualified by the law, now the child's actual custodian will be going over the child's actual custodian over 21 years old unless, okay, chosen, or unless unfit or qualified. Now, what if, I again repeat, what if the child does not have an older sister or an older brother over 21 years old? Now, the parental authority or the substitute parental authority will be given to the actual person who is taking in charge of this person on that particular situation. So, for instance, is that I am considered here an abandoned child, or there I have no brothers, I have no grandfather, I have no sister or brother beyond 21 years old. Whoever is the one taking good care of me as of this moment, or up to this moment, will be the person who will be having the substitute parental authority. Well, unless if it is disqualified or considered unqualified by the court. Okay? So, according again to Article 19, the absence of or death of parents, the grandparent in their default, maternal or paternal, will be the one to take charge. If they are not present, the older brother beyond 21 years old, or sister at least, okay, 18 years of age, or relative to person who has the actual custody. Okay? So, we have the filial privilege here that no descendant shall be compelled in criminal case to testify against her parents. So, again, remember the tender years presumption. No child under 7 years of age shall be separated from his mother unless it is chosen unfit, and the courts find any compelling reasons to do so. Okay, there are many stare decisions or decisions of the court before. Example here is our Agnes Hirsch versus Franklin Hirsch. Okay, GR number 174485, July of 2007. So, what are the examples of compelling reason? Okay, the compelling reason as provided for by this sample stare decisions or stare decisions is neglect, abandonment, unemployment, immorality, drug habituation, drug addiction, insanity, or any other similar forms. Now, there are some amendments by the way of this. We remember the family court reversed the provision of reducing the child to age of 5. Okay? So, let us go back to this guardian. We mentioned a while ago that what if the parent, if the court will find any guardian, or the person or the child will be given a guardian. Okay, who will select this guardian? According to Article 20, the guardian will be selected by the court. Of what particular court is this? It will be the family court. Okay, and then it will be the court will appoint a guardian for the person and property of the child. Okay? On petition on any relative of or friend of family or the Department of Social Welfare. So if there are petition coming from his relatives or his friend, or if his friend is not present, or his relative, or he has no relative to file for this, then it will be the Department of Social Welfare and Development who will file for this petition to look for a guardian. Grounds of abandoned child or neglected child or the like, okay, there is still a need for a case study. Okay? This case study will be conducted by authorities, okay, social welfare offices, to prove first that there will be what you call as an abandonment or neglect of these children before they will be classifying this as qualified for the selection of guardian. Then still, of course, they need to have their hearings. So there will be a lot of hearings. There will be there will be trials that will be conducted by the court, of course, or by the family court. Now the hearings, remember that all hearings are still to be considered confidential. Okay, that's according to Article 25. Hearing on the guardianship and custody proceedings may, at the discretion of the court, be closed. So in case the court see that there is a need for this hearing to be closed, it will be kept, okay, and not to be released without its approval. Okay, in this case is to protect the child's welfare, of course. According to Article 228, okay, parental authority will terminate permanently if the child or if the parents died. Okay, both parents, the father and the mother, has died. Then the termination of the rights over the person and property to the child already diminishes or terminates. Upon the death of the child will be one of the reason that the parental authority will be terminated, or upon the emancipation of the child. Okay? Remember that contracting marriage shall require parental consent, by the way, until the age of 21. So, parental consent for marrying as provided for by PD 603 shall have parental consent until the age of 21. Okay? Now, the grandparents' role is that the grandparents still could be consulted on important matters or questions, but if they shall not interfere, on the exercise of parental authority by the parents. That is on Article 81. So, the parental authority of if both mother and father is still there, okay, the grandparents' role is only for consultation, and they are not allowed to interfere on the rights or the parental authority over the child. Well, unless there is no child, there is no guardian, okay, it will go to the grandparent, just like what we have discussed. Okay? So, again, the age of majority commences at the age of 18 years old. And then when you speak of emancipation, this is the freedom. Okay? Emancipation comes in during the termination of the parents' parental authority over the child. Okay? Emancipation also takes place when by marriage of the minor, by the by recording of the civil register of an agreement in a public instrument executed by parents or parents exercising parental authority, and the minor at least, okay, is 18 years of age. So emancipation also takes place not only the time you are free from your person or property, also during the time the child married, and then there is a civil registration and agreement between the minor and then the